Have you ever found yourself in that really uncomfortable spot at work, feeling like, I don't know, you were singled out,
Mm.
maybe sidelined right after you voiced a concern, or maybe made a complaint?
Yeah, or maybe you've been on the other side, right?
Yeah,
Trying to manage a situation with an employee who suddenly feels, well, targeted after something happens.
exactly. Workplace retaliation.
Hmm.
It's not just some legal term you hear about. It's this incredibly personal and honestly deeply charged issue. It feels like it cuts right to the heart of our human experience at work.
Hmm.
So today we're doing a deep dive into this really complex topic. We're pulling back the curtain on some surprising dimensions, all through the lens of this really compelling live session led by Louis Lessig.
The employment law translating.
That's the one. I
Yeah.
know him by that name. And he just has this way of delivering insights with like an almost magnetic energy and a directness that really makes them stick.
That's so true. And for this deep dive, I really want you, our listener, to try and imagine yourself right there in the audience. Maybe you're at a big HR conference, down in Orlando, or perhaps a more focused corporate training session somewhere like Chicago.
Right.
Because Lessig's approach, it isn't about just clicking through dry legal statutes on a slide. It's really about the human element, the raw, immediate reactions we all have.
Okay.
So our mission today is to unpack those surprising physiological and, yeah, emotional dimensions of retaliation that honestly get overlooked so often in typical training.
And more importantly, what we can actually do about that.
Exactly. He really challenges the usual way of thinking, turning what can be a pretty dense topic into something, well, remarkably accessible and actionable. I found it super engaging.
Okay, let's unpack this then, because Lessig, he really doesn't waste any time. He jumps right in. He often opens his sessions by just stating flat out that retaliation gets to the core of our essence as humans. When I first heard that, sitting there in the audience, it really landed. It's such a powerful statement. Why do you think that particular phrasing hits so hard, especially in a professional context?
Well, what's truly fascinating about that is how he frames it. He sees retaliation as fundamentally charged because it taps right into our deepest, most primal human instincts.
Instincts. Oh, too.
Yeah, think about it. When someone feels retaliated against, it often feels like this fundamental breach of trust, right? A profound unfairness. It's about power, vulnerability, perceived justice, all that stuff.
Right, it feels personal.
Totally.
Yeah.
And Black's Law Dictionary, which Lessig often references, defines retaliation as, and I'm quoting here, to take action against another in a vengeful fashion as a result of some prior act.
Wow. Vengeful. That's a strong word.
It really is. And that word vengeful, it immediately tells you this isn't just about, ticking a box or following some dry policy. It's about these deeply ingrained human responses to feeling wronged or attacked, and that often unconscious desire to, well, strike back.
So it's not just an employment law thing.
Not at all. It's deeply psychological, too.
And it's clearly not just some abstract legal concept either. Lessig drives this home with really striking statistics. And he uses live polling in his sessions, which is such a great way to make the numbers feel immediate.
Yeah, that polling really gets people's attention.
It does. He revealed that a staggering 52% of all EEOC charges for 2023, that's over 81,000 total charges nationwide, included a retaliation component.
Think about that.
Right. Retaliation isn't just a problem, it's the majority of employment discrimination cases being filed. It means even if the original claim, say discrimination or harassment, doesn't ultimately hold up.
The retaliation claim often does.
Exactly. That's the part that sticks.
And if you connect those numbers to the bottom line, they aren't just stats on a page. They translate into absolutely enormous financial impacts for organizations, all sizes.
He really emphasizes that, doesn't he?
Oh, absolutely. Lessig isn't just talking hypotheticals. He highlights the very real, often staggering attorney bills. We're talking six-figure bills, sometimes even for no-cause verdicts where the employer actually wins the case.
Wait, even if you win.
Even if you win. Imagine being found completely innocent, but still facing, say, a $250,000 legal bill or more.
Ouch.
And then, of course, there are the multi-million-dollar settlements when things really go wrong. Lessig used a big name like Walmart as an example, not saying they were being sued in that instance, but just to illustrate the scale of costs some companies face when a retaliation claim escalates.
It makes you stop and think.
It really does. He puts it right to the audience. What's it like for you in your operating budget? Because these aren't just problems for huge corporations. They hit organizations of all sizes, from a small business in Kansas City to a tech firm in Silicon Valley. It can genuinely cripple an operating budget.
What I also found really engaging, and he makes sure to hit this point hard in his live talks, is how he challenges assumptions about where these charges pop up most.
Right. Most people guess the big coastal states.
Yeah, you immediately think California, New York, maybe Florida. But he pulls up the data. And when you look at population versus the actual number of charges filed, boom. Unexpected states like Tennessee, Arkansas, even Georgia consistently rank in the top 10.
That's surprising.
It really is. It drives home his point perfectly.
Yeah.
It's much more local than you think. It's not just some big city issue. It's happening everywhere, in every corner of the country, affecting all sorts of businesses. Okay, so here's where, for me anyway, it gets really interesting. This is where Lessig truly sets himself apart. He doesn't just stick to the legal stuff. He dives deep into our physiological responses to these claims.
Yes. The body's reaction.
I can still picture him doing this, asking the audience to actually stand up, take a deep breath together, just to physically feel and demonstrate the immediate impact stress has when you're confronted with something difficult.
It's a powerful moment in the room. Very tangible.
It really is. It shows how deeply this stuff affects us, like physically.
And it's all about that fight or flight response, isn't it? We've all heard the term, but Lessig drills down into what it means in this specific context. It's critical.
Explain that a bit more.
Well, he explains that when a manager, or really any individual, is confronted with a retaliation claim, or even just the threat of one, their body immediately, instantly, unleashes this flood of stress hormones, adrenaline, noradrenaline.
A classic stress cocktail.
Exactly. And this triggers a whole series of involuntary, totally reflexive responses. Your heart rate skyrockets, your breathing gets fast and shallow, muscles tense up, your vision might even narrow. Some people even have panic attacks.
And the key thing is,
the crucial part, as Lessig really hammers home, is that you don't get a say in it. Your body just does it. It's primal, it's hardwired for survival, not really designed for navigating complex HR dilemmas calmly.
And that's precisely where the danger lies, right? Lessig's critical observation, and you can tell this comes from years of litigating these cases, is that this adrenaline rush, this state of heightened physiological arousal, lasts for anywhere from 20 minutes up to a full hour.
A whole hour, potentially. Wow.
Right. And during that absolutely critical window, managers, kind of overwhelmed by this involuntary biological reaction, are often making reactive, emotional decisions.
Snap judgments.
Exactly. Decisions that can cost an organization dearly. He drew this really sharp contrast. He said traditional discrimination-focused training is usually victim-centric. It asks, how does the plaintiff feel? What was the impact on them?
Right. Focuses outward.
But the correct retaliation focus, he argues, fundamentally shifts the lens. It becomes individual-centric, forcing managers to look inward. It's no longer just about the plaintiff's feelings, but about questioning my own actions, asking, what did you, the manager, actually do?
That's a huge shift.
It's a complete paradigm shift, and one that, unfortunately, many people miss.
Which raises that uncomfortable question, really. Why aren't we consistently training on this crucial distinction? Lessig, he brings this to life so vividly with his what-if game scenario. He tells this story.
I remember this one, the general counsel.
That's the one. A true story, apparently. A highly educated lawyer, a general counsel in a federal courthouse setting, about to settle a case, and was completely missing the need for a critical no rehire clause in the agreement.
Even though he's a lawyer.
Even though he's a lawyer. He was completely oblivious, Lessig says, to the fact that he was essentially setting the company up to buy a brand new retaliation claim the second that employee reapplied or tried to come back.
How could that happen?
Well, turns out the GC's expertise was in complex mergers and acquisitions, not the nitty-gritty, but absolutely crucial nuances of employment litigation.
Wow. So specialization matters.
Hugely. And that anecdote just vividly illustrates the dangerous lack of understanding that can exist even at very high levels. It proves that intelligence, even legal training, doesn't automatically protect you from these pitfalls if you aren't specifically trained on employment law realities. That tiny detail, missing the no rehire clause, could have triggered another massive payout.
It's those direct, sometimes kind of raw personal stories, often delivered with, a good dose of humor and bluntness.
Yeah, he doesn't pull punches.
No, he doesn't. And that really solidifies his reputation as the employment law translator. He uses these stories to make these, abstract concepts, physiology, legal nuances, incredibly tangible and memorable, not just for HR folks or lawyers, but for everyone in the room.
You feel the intention.
Totally. You can feel he wants people to get it in a way that actually sticks and changes how they behave. He's not just lecturing. He's translating complex stuff into, actionable understanding. So, okay, Lessig's session isn't just about pointing out the problem or hitting you with scary stats and biology lessons. His whole session immediately pivots to practical, actionable steps, a different, more effective approach. He doesn't just leave you hanging.
Exactly. He offers a clear path forward. He outlines what he calls your next options for addressing retaliation. And these are specifically designed to counteract that immediate emotional fight-or-flight thing we just talked about.
Okay, what are they?
So first, consider how you treated the person before the claim. Foundational. Were you consistent? Fair. Did you follow policy? Your pre-claim behavior is either your strongest defense or your biggest weakness.
Makes sense. Baseline behavior.
Second, allow a moment to center yourself. Recognize that crucial 20 to 60-minute physiological recovery time we mentioned. Consciously choose to let your body and mind calm down. Step away, take a walk, deep breaths, whatever works. Sounds simple, but it's incredibly powerful.
Pausing before reacting. Got it.
Third, understand your feelings. This is about self-awareness. What exactly about this employee or this situation is really bugging you? Is it perceived unfairness? A challenge to your authority? Just the inconvenience. Naming it helps calm that noradrenaline rush, lets you act rationally, not reactively.
Acknowledge the emotion to manage it.
Fourth, strategize. Don't just lash out or make a quick decision. Think deliberately. What's the actual objective here? How can you achieve it legally and appropriately? This is where you bring your thinking brain back online.
Plan the next steps carefully.
And fifth, crucially, enlist the assistance of professionals. He really stresses this. Do not try to handle it alone. Reach out to your HR colleagues, your C-suite leaders, and critically, legal counsel, as Lessig sometimes puts it, quite bluntly, for the love of God, ask for help.
Yeah, I remember him saying that. He also gives some very firm advice delivered in that incredibly memorable, direct way. Do not react.
Simple, but hard to follow sometimes.
It is. And he distills it down to this choice, which he often presents right to the audience's faces. You have two choices. You can talk to me now. We can figure out how to set things up properly. Or you can wait until the lawsuit's filed.
Ooh, stark choice.
It perfectly captures his pragmatic, no-nonsense approach. It's about prevention, about stopping these things from escalating into hugely expensive legal battles. It's a real wake-up call for anyone thinking they can just wing it.
And during the Q&A in one session I attended, someone asked a really good question. Should you actually change your behavior towards the employee if maybe your initial behavior was problematic?
Oh, that's tricky. What did he say?
He offered a really important nuance there. He said, look, if the initial behavior was actually discriminatory, if you were treating someone unfairly based on a protected characteristic, then yes, absolutely, stop immediately. That's non-negotiable.
Okay, obvious.
But generally, you shouldn't suddenly change established non-discriminatory processes like regular performance reviews or standard disciplinary procedures just because a claim was filed. Doing that can actually look like retaliation itself.
So changing normal practice is risky.
It can be. However, he clarified, you might need to change who is involved. For instance, if the manager is the one named in the complaint, maybe HR or a different senior leader should take over managing that employee's performance just to ensure objectivity.
Makes sense. Remove the potential conflict.
Exactly. And crucially, he emphasized the huge importance of documentation, things like performance improvement plans or PIPs. Having a consistent, well-documented approach is the backbone of your defense. It demonstrates any actions taken were based on legitimate business reasons, not some retaliatory motive.
Documentation, documentation, documentation.
Always.
And that really leads to his core message wrapping up this whole section and really his entire approach.
Right.
This problem of workplace retaliation, it can be fixed, the costs can be mitigated.
But it takes work.
It does. It requires this fundamental proactive shift in how we actually train and prepare managers. It's not just about teaching rules and regs. It's about equipping them to deal with their own gut-level innate reactions when a claim lands on their desk, focusing first on self-awareness and self-management before making any decisions.
That's the real training gap he's trying to fill.
Exactly. That's what feels different about his approach.
Mm-hmm.
So as we bring this deep dive to a close, the core message from Louis Lessig, the employment law translator, seems undeniably clear. Effectively tackling workplace retaliation really hinges on understanding and managing our own responses, those often subconscious emotional and, yes, physiological reactions.
It's about recognizing that immediate fight-or-flight instinct kicking in,
Pausing.
and then proactively choosing a different, more rational path forward. It's not just about legal compliance, is it? It's almost like mastering human nature within the workplace context.
Oh, of course.
And that leaves us with maybe a provocative thought for you, the listener, to chew on. If we as leaders, managers, HR pros, if we don't really understand our own ingrained fight-or-flight reactions when a retaliation claim hits, how can we possibly expect to manage these super complex workplace conflicts effectively? How can we make sound decisions and actually mitigate the massive costs, both financial and human, that these claims bring?
It's a powerful question.
It really makes you think. It's not just about knowing the law. Maybe it's just as much about knowing ourselves.
Louis Lessig is just so valuable in this space. He's an active employment litigator. He brings that real-world pragmatic approach directly to employers, and he's genuinely willing to support and work with pragmatic organizations, with leaders who are interested in adopting these kinds of crucial mindset shifts, really transforming their approach.
He wants to help prevent the problems, not just clean them up afterwards.
Exactly. So if you're listening and thinking you want to connect with him, explore how these insights might apply in your own organization, you can email him directly. His email is hcplasig@brownconnery.com. That's LLESSIG @brownconnery.com.
Or just pick up the phone.
Or just call his office. Simple
Yeah.
as that. The number is 856-854-8900. Again, 856-854-8900. Thank you so much for joining us on this deep dive today and for investing in your own knowledge. We really hope this has given you something truly valuable to think about and maybe even implement.